Get started and figure out some of the tech. So welcome to our second Human Rights in Practice event of this semester, organized by the Center for International Comparative Law and the Duke International Human Rights Law Clinic. Our event is titled Poverty, Movement Building, and the Protection of Civic Space. And our event today is also part of International Week. And a welcome both to our audience here in person with us and also those watching via live stream. Thank you all for being here. Before introducing our two speakers in just a moment, I'd like to thank our co-sponsors, the Duke Human Rights Center at the Franklin Humanities Institute, the Duke Human Rights Center at the Kenan Institute for Ethics, and two student groups, the Human Rights Law Society and the International Law Society. Now turning to our speakers, we will first hear from Kate Barth, Legal Advisor with the Global Programs Team at the International Center for Not-for-Profit Law, ICNL, where she manages several multi-regional programs, including in Kenya, Malawi, Myanmar, and elsewhere. Kate's work also focuses on efforts to counter shrinking civic space through advocacy, capacity building, and research support to civic society. Her expertise and research focus on protection and due process mechanisms at international human rights bodies, and Kate has published on a wide range of topics, from the best tactics for international human rights advocacy to legal provisions, inhibiting developments in multilateral loan instruments. We will then hear from Professor Domingo Loveira Parmo. Professor Loveira Parmo is the co-director of the Public Law Program and a professor in the Public Law Department at University of Diego Portales in Santiago, Chile. His research focuses on the right to protest and constitutional law, social rights, and the constitutional rights of children. Among many other publications, he recently authored a chapter on human rights, poverty, and mobilizations for the Research Handbook on Human Rights and Poverty, which was published just this year. So both speakers will speak for approximately 12 to 15 minutes, and then we'll open it up at 1 for a discussion and questions. Also to note that we will finish per the new protocol at the law school at 1:15 to make sure everyone has a chance to grab lunch and have some time to eat before heading off to class or your next event. So with that, I will hand it over to Kate to get us started.
Okay, great. I'm going to go ahead and share my screen. Hopefully this will work again. And I should mention the only person I can see right now is Domingo. So I'm not sure if that really matters, but I guess if people have reactions or questions during the presentation.
Okay, yeah, I'm sorry about that. I'll definitely, once questions come up, I can, as moderator, point to people here and also repeat the questions.
Okay, great. So, hello to everyone. As mentioned, I'm Kate Barth. I'm a legal advisor with the International Center for Not-for-Profit Law, which is an organization that works to fight closing civic space around the world. And that is what I'm going to be talking to you guys about today. Now, what is this really? Well, over the past few decades, we've basically seen governments around the world using law to cut back on people's ability to associate, assemble, and express themselves freely. This has really gone kind of hand in hand with the rise of authoritarianism around the world. So over the next 15 minutes, I'm going to give you guys a very quick overview of some of the most common legal tactics used to constrain civil society, as well as some of the most concerning trends that we've seen emerge in the last couple of years. And I'm hoping that you guys are going to walk away from this presentation kind of better able to recognize problematic restrictions where you see them. And as I mentioned, we'll have some time at the end for questions in case any of those come up. So let's start with the basics. Is participation in civil society a right? Yes, it indubitably is. There are 3 rights in particular that guarantee your ability to participate in civil society, and these are the rights to free association, assembly, and expression. Collectively, all refer to these rights as civic freedoms, and they're embedded in numerous international human rights treaties and instruments, including, as you see on the screen there, the International Covenant on Civil and Political Rights. However, those of you who have studied international human rights law will know that these rights are not totally without limitations. In very specific situations, restrictions can be placed on one's civic freedoms. but such restrictions must be justified using a three-part test. Now, unfortunately, I don't have time to go into the specifics of the three-part test today, but it's important for you guys to keep in mind that just in general, restrictions are only permitted in a very limited set of circumstances for a particular set of ends, such as public safety or public health, and any such restriction must be as minimal as possible. Now, unfortunately, in recent years, really, I'd say about the past 2 decades, we've witnessed a closing of civic space, that is the legal space in which individuals and groups exercise their civic freedoms. You can see from the map that I put on the screen that since 2015, 86 countries have proposed or enacted more than 221 restrictive initiatives affecting civic space. And actually, I have to admit that I haven't updated the slide since March, so it might even be, might be some more now. The other unfortunate thing that this map tells us is that this trend is truly global with no region immune. And unfortunately, the trend applies not only to authoritarian states, but also to democracies. Basically, we're seeing governments relying on quite a diverse range of laws and regulations to constrain civic space. So we're not only talking about restrictive, NGO laws here, but also about tax laws, funding laws, defamation laws, cybercrime laws, of course, counterterrorism laws, laws on statistics, laws on transparency, so on and so forth. So today I'm going to talk to you guys about the top 4 categories of restrictions that we see, and I'm going to start with life cycle restrictions. Now, what do I mean by life cycle restrictions? So these are basically restrictions on the way that civil society organizations, or CSOs, form, the way they operate, or the way they can be shut down. So governments pass laws concerning all stages of a CSO's life. But I'm just going to give a few examples of formation restrictions. And I was hoping to do this in a pop quiz format, but since I can't see you guys, and I'm not sure if people can add into the chat, I think you'll just have to think your answer at me very loudly. So the question is, in Turkmenistan, how many people do you think are required to found a national association or an NGO? Is it 25, 75, 150, or 400? Well, all right, I think I'm just going to give you guys the answer to this, which is, of course, D, 400. So here's a picture of you and 399 of your closest Turkmeni friends who you are going to need in order to register your, let's say, your Harry Potter Appreciation Fan Club. Next question. What do you think is the minimum amount of capital required to found an Eritrean NGO? Again, just think your answer at me as loud as you can. Is it $1,000, $50,000, $500,000, or $1 million? Well, those of you who guessed $1 million would in fact be right. Now, keep in mind that Eritrean GDP per capita in 2020 is about $650. So what we're talking about is 1,500 years of income. I put a picture of Eritrea up on the screen for you. These people do not have $1 million to start their Harry Potter Appreciation Fan Club, or, maybe more to the point, their advocacy group to get the government to deliver humanitarian necessities to their neighbors in the desert. So those are just examples of common barriers to entry. Other very common restrictions that we might see are laws that would prevent certain types of organizations from forming. So for example, in Nigeria, the Same-Sex Marriage Prohibition Act prevents any LGBTQ organizations from forming. I have to say, I think just last week I saw a very similar law, or a bill, which has been proposed in Ghana. You also very commonly get registration systems that would allow the government to filter what organizations are permitted. Now, keep in mind that these laws are basically coupled with a criminalization of unregistered informal organizations. So what you get effectively is a system that bars informal groups from registering and then would fine or put people in prison for participating in those groups. Okay, so that was just some examples of formation restrictions, which keep in mind is just one type of life cycle restriction. But let's move on to free speech. So in some places, critical speech is directly criminalized, kind of easy peasy. But in other places, the methods are more subtle. So, for example, in 2015, Tanzania passed a statistics law with the stated purpose of improving the quality of public discourse by ensuring that all facts and statistics disseminated in the public realm would be accurate. The act made it a crime for anyone, a CSO, a politician, whoever, to publish false official statistics or to disseminate any information that distorted the fact. Okay, so on one hand, maybe this sounds great to you, especially for those of us who might be, familiar with the evils of disinformation. Like, who doesn't want a law that would only allow kind of truthful facts to be put into the public discourse? But of course, that's not really the way this works in practice, because the arbiter of what statistics are truthful is the government. And as you can imagine, this really doesn't go down that well for anyone publishing any information that conflicts with an official narrative. This is the type of fake news law that we've seen proliferating recently, which, if done poorly, basically allows for the government to censor or criminalize speech that it deems to be untruthful. And we're also seeing a whole spate of cybercrime laws that would effectively criminalize critical speech online. Moving on, I want to talk about barriers to funding, because this is a huge problem, and I think it's one that gets a little less attention in kind of mainstream media than some of the other restrictions that I've talked about. So basically, an increasing number of countries constrain the ability of CSOs to receive international funding, including cross-border philanthropy. Generally, the stated rationale for doing this is to prevent money laundering or terrorism financing from funneling through the civil society sector, which shockingly is actually not at that big of a risk for terrorism financing. Another rationale the governments will give will be to provide, transparency to the citizens on sort of the scary foreign powers that are allegedly controlling their local grassroots CSOs. So, for example, some countries will, entirely prohibit foreign donors from funding local organizations, or they'll require specific permission from the government before any such donations can be accepted. India is a pretty major offender here. On the screen, you'll see a private circular that wasn't ever meant to be made public that was sent to Indian banks, prohibiting them from processing funds sent by any of the listed donors. Now, just take a minute and look at the entities that are actually listed here and ask yourselves whether any of these really seem like a terrorist organization who might be trying to launder money through an Indian CSO, or who might be trying to undermine Indian, national security. I mean, I don't know, maybe like Musicorps is shadier than we think, but generally I think these are some pretty legitimate entities still on the blacklist, as it were. And I should mention, this was actually quite personal to me, because I was actually working in India for one of its foremost human rights law organizations when this Indian law kicked up into high gear, which ultimately led to the shuttering of the CSO, as well as a criminal indictment against the founder himself, who was a former UN Special Rapporteur on the right to health, so not a particularly shady person, but also, possibly a critic of the Modi government, which is probably why the organization was targeted. Another very common issue we see with this international funding is the stigmatization of international funding through so-called foreign agents legislation. So what does this look like? Well, in 2012, Putin signed a law, for example, requiring that all CSOs that receive funds from abroad and engage in political activities register with the Ministry of Justice as foreign agents. Now, under the law, political activities was very broadly defined as, quote, attempts to influence official decision-making or to shape public opinion for this objective, end quote. In other words, pretty much all advocacy activities. And I think it bears mention that this label is particularly problematic for Russian CSOs, because in Russian, the term foreign agent is actually synonymous with foreign spy. And as you can see from the example I've just thrown on the screen, these laws are incredibly malleable. And it's, just an example of kind of how absurdist they can get. Fun fact here, the United States was actually the first country to introduce a foreign agents law, which I believe Congress is currently considering expanding in some ways that we would think somewhat problematic. Okay, so let's move on to assembly. So what are some of the legal constraints that we often find around the right to assemble, demonstrate, protest? Well, many countries require any demonstration to have first obtained government approval. We also see a whole spate of what we refer to as time, place, and manner laws. In other words, these are laws that say, yes, you can protest, but only at the time, in the place, and in the way that the government tells you is okay. And of course, usually that time, that place, and that manner is very inconvenient and sort of designed to kind of, shuffle your protest out of sight. We also see laws that contain content-based restrictions. So in Russia, you can't have protests related to LGBTQ matters. And my personal favorite, a whole series of laws that provide liability for organizers with respect to cleanup or violence that might occur sort of around the edges of the protest. Here's an example of one of those latter laws. So in Burundi, the law attributes both civil and criminal responsibility to the organizers of any public gathering, including, I assume, jogging groups. And this obviously chills protest, right? Because if I told you that you were personally and potentially criminally responsible for any messes that occurred during a protest or, jogging group that you organized or joined, probably you wouldn't organize or join a jogging group or a protest. And that's exactly what we've seen in Burundi. People are really worried about organizing very, kind of innocent things. Of course, when it comes to protests, there is always practical constraints as well. These are things like surveillance, stigmatization of protesters. We saw that this year in the US with the BLM protests, physical constraints, and of course, if none of that works, there's always the old-fashioned way of physical intimidation of protesters through the use of lethal or less than lethal force. Okay, so that was a very quick cruise of some, but not all, of the very common restrictions that we've seen. But I want to turn now to some of the let's say, hot topics, some of the new trends that we've seen over the past couple of years. And here are the three that I would say are really the ones to keep an eye on. Let's start with COVID-19, which unfortunately, in addition to being a public health crisis, has also ushered in a parallel civic freedoms crisis. As you can see from the slide, since the beginning of the pandemic, at least 176 countries have enacted 546 measures that affect human rights. Guys, the pandemic is only about a year and a half old. It's not been that long, and 546 measures in a year and a half is a lot of restrictive measures. Now, surely when you think about COVID-related restrictions, you're thinking about restrictions on assembly, right? Like gathering together in crowds. But in truth, the restrictions that governments have issued in response to COVID are actually quite varied, and you can see some of them on the slide there. In practice, what we're seeing are things like cracking down, just on opposition activists during the pandemic, police brutality and enforcing quarantine curfews, cyber patrols of social media during the pandemic, so on and so forth. One trend that both predates COVID, but has also been exacerbated by it, is that of securitization. Now, securitization occurs when an issue is presented as an existential threat, requiring emergency measures and justifying actions outside of the normal bounds of political procedure. First of all, we're seeing this in the rhetoric, right? Governments are talking about, a war on COVID, or they're calling themselves wartime presidents. And here we have a lovely picture of the president of South Africa, who for some reason decided to address the nation in army fatigues. But it's not just the rhetoric. Several countries, Serbia, Lebanon, the Philippines, and others, have actually deployed the military to enforce emergency measures. In fact, Duterte, who's the president of the Philippines, appointed former military leaders to run the COVID-19 response and actually issued shoot-to-kill orders, which doesn't really sound like a public health measure to me, but what do I know? On the screen, I put a picture of the Jordanian COVID response, and you look at that, and it's just like, what are they going to be doing with all of those tanks? I mean, are they running vaccine centers from them? But as was the case with our post-9/11 kind of war on terror rhetoric, casting COVID-19 as a national security threat makes it much easier for the government to defend extraordinary measures that infringe, rights and freedoms and really undermine civil society's ability to push back. And it kind of makes you wonder, like, what's next, right? I mean, our government's going to start declaring, war on climate change, and then they're going to roll out a bunch of tanks to fight climate change in some way. Lastly, let's talk about technology for a minute, which obviously can do some good things. The rise of the internet, digital communications, social media, these have all given people new avenues to share ideas and organize activities. It's given better access to information. Technology can give CSOs a better ability to fundraise. I bet we're all probably familiar, with like the Arab Spring narrative around the role of social media in mass mobilization. But there is a dark side. As more communications move online, there are more opportunities for governments to monitor those communications, which many governments have done very effectively. Some governments, including in Indonesia, Pakistan, Tanzania, for example, have adopted cybercrime laws and other regulations that provide largely unfettered power to monitor and surveil electronic communications. These laws are often given further potency by the inclusion of very broad prohibitions on very ambiguously defined categories of speech, thereby really just opening the door to infringement on freedom of expression, freedom of association, and of course the right to privacy. So I know that I'm probably running over time, as I want to do, but I do want to end on a note of hope. It's not all negative. This chart shows the proportion of restrictive initiatives versus enabling initiatives proposed or adopted since 2015. And I think it's an important reminder, it is possible to oppose restrictive measures and in some cases even make progress, as this chart shows. Here we have a little list of some places where in the past couple of years we have seen some legal progress made. And with that, I will end, leaving you guys with some resources. And I don't know if you want to have questions now or maybe after Domingo speaks.
Yeah, why don't we turn to Domingo and then we can turn to questions after that.
Okay, great.
Kate.
Okay, so I can share screen now.
Great.
So hi everyone, thanks Aya for the invitation to this talk, and thanks Kate for your great presentation. I was taking note of everything you were saying, and it's very useful for the kind of work we do here. I'm going to share a screen as well. I might be talking from a more conceptual viewpoint, but I think it's very, very related to what Kate was just presenting. So I'm going to talk about protest, the role of law in this, and Kate has been pretty clear that it has not been a very good role in enabling protest, and maybe pose a question of how we can bring other principles into the conversation, such as equality, so we can actually enhance the possibilities of having the right to protest vindicated once again. I want to place a couple of notes of context, and Kate just mentioned the first one I want to mention as well. We are going through a pandemic, hopefully during the last, stages of the pandemic probably. But governments have put a lot of measures which include restrictions on the use of public space. And of course, evidence shows that these are one of the best ways to flatten the curve. But at the same time, we can't forget that, as Kate mentioned, something about more than 500 measures have been implemented in different governments around the world that have restricted the use of public space. So I just want to place a note of caution here. We have to take into account whether, I keep an eye on whether these measures will be removed or will remain. The second thing, and human rights organizations and bodies have warned about this, is that, something Kate also mentioned, governments found in the pandemic a chance or an opportunity to limit public appearances that otherwise it could have been very difficult to restrict or to contend. This was the case of Chile, for example. By October, November, December of 2019, we were facing huge public demonstrations. This is the reason why we are now in the middle of a constituent process. I was just taking a look at the conferences and the transmissions of the Constituent Assembly that is taking place now for 3 months in Chile, and the government was facing this huge mobilization. So in a certain way, the pandemic came as a lifesaver for the government, who was able then to implement these very restrictive measures on public participation and on protest. So many governments around the world have been using the same opportunity of the pandemic to place these restrictions. And again, the warning is, let's keep an eye on whether these measures are going to be removed once the pandemic hopefully goes away. So I want to make 3 points about in this presentation. First, the relevance of protests for a democracy, and I think we are all pretty clear about which is the relevance of protests and demonstrations for a representative democracy. As far as I'm concerned, I love to rely in Professor Nadia Urbinati's theory of representative democracy. She has explained that representative democracy is the government of two queens or two sovereigns. One is the sovereigns of the democratic will, which is procedures, highly detailed in the laws, in the constitutions, and in the bylaws that we examine in the school of law. But the other sovereign, the other queen, is the queen of public opinion, which is not detailed, is not regulated, is more amorphous, and sometimes it's difficult to grasp. But it is the interaction between these two sovereigns, between these two queens, which gives representative democracy forms. And the challenge we face, probably we're not going to see how this is going to be finally settled, but the challenge we face normally is trying to strike the right balance between public opinion and between democratic will. So they establish kind of a conversation, Urbinati says, which is tense at times, and protests sometimes are very tense and very disruptive of regular life. But this conversation between these two queens, these two sovereigns, is what gives representative democracy its normative foundation. So protest is one way, not the most important. I like protests. I have studied protests, but it's just one way through which the people take part, participate in building or in shaping public opinion. So protests are, from a constitutional viewpoint, a form of public discourse, and this is the reason why they are or should be protected by constitutional rights and freedoms. So, in a way, protests are a form of conversation and a form of contribute to democratic will. In the end, public opinion, as James Madison was pretty clear in 1791, sets the bounds on every government, and government should respond to public opinion. If protests are important for representative democracy in a more general sense, they are of utmost important for poor people or for displaced groups. Sometimes for these groups, protest is the only means they have at hand to participate and shape public opinion. They don't have opportunities to write op-eds in the newspapers. They don't have money, as Kate just has explained. Sometimes the requirements are quite high, but they don't have money to pay advertisements in the newspapers. They don't have a direct line with representatives. So the only means they have at hand sometimes is just to protest and to demonstrate. And this is actually a viewpoint that has been assumed in international human rights law and in many constitutional jurisdictions. They know that protest is sometimes the only main means available for some groups. This is, for instance, what the Constitutional Court of South Africa said in an important case a couple of years ago. The right to freedom of assembly is central to our constitutional democracy. It exists primarily to give voice to the powerless. This includes groups that do not have political or economic power to participate in the formation and shaping of public opinion. So, for certain social groups, protest fulfills two functions. On the one hand, protest allows these groups to participate in the public debates, and at the same time, protest becomes a mechanism through which they can pose them fulfilling social demands in front of the states. Now, what is the problem? The problem, I think, is that both international human rights law as well as domestic constitutional schemes have welcomed protest regulations without paying social relations of power too much attention. This is something that Kate was mentioning about the manner, place, and time and regulation. So let's play in the last part of the presentation, a quick look at what does the law do in regards of protest. So the first thing is that law secures rights, and that's okay. But at what cost? And this is what we should bear in mind when we are dealing with the regulations that have been imposed on the right to protest. So Article 21st of the ICCPR that Kate mentioned at the beginning of her presentation says that the right to peaceful assembly shall be recognized. And this is, I think, very important, I think, because only peaceful assemblies are covered and protected. And and of course, we can have a long conversation or a debate about and what is a peaceful assembly. So if you cut the streets, if you cut transit, if you bring disruption to regular life, if you are protesting because you don't have access to housing, and I was on my way to a concert when this was possible, or to a soccer match, I'm going to be dissatisfied. Is that a violent kind of exercise of assembly? In any case, what calls my attention from this article, and this is an absolute trend in almost every constitution in the globe that recognizes the right or freedom of assembly, is this specific requirement that public meetings should be peaceful. And I agree with that. I think that public meetings and protests should be peaceful. But why legal instruments such as international treaties or constitutional bodies require this specifically from freedom of assembly? As long as I know, every freedom, every constitutional right, and every constitutional equality is to be exercised pacifically or not violently. So why we include this specific requirement for freedom of assembly? And of course, there is an explanation. The explanation, I think, is that from the liberal constitutional tradition, well, the state was meant to put the multitude into brackets, so it can be replaced by representative power. And this is why I think, as Judith Butler magnificently has explained, liberal constitutionalism and liberalism in the end gets nervous when the actual people, shows up in the street with their bodies and their stories. So this is one first approach that tells pretty much why the law does what it does, which is limits the appearances in public of the people, because it feels nervous and discomfort with actual people occupying the streets. The second problem, I think, with the legal approach to the right to protest is this kind of the coupled approach that law normally assumes. So law secures the exercise of rights, but it does so in a formalistic fashion. Again, this means putting the social relations of power between brackets. How this manifests in the case of the right to protest? Well, CPM regulations, again, which has been actually included in the General Comment number 37 that the Committee of Human Rights has just published during late 2020. So, which is the idea of this time, place, and manner regulations? The idea, which has been welcomed by the international human rights law, is that we can have a way of reconciling the different interests that are in play. So the idea is that we have a negotiated management of protest. So all parties will be seated at the same table, so we can discuss and negotiate, actually, which is the manner, the time, and the place of a specific protest. And by all the parties, I mean the police, the administrative authorities, and those who are organizing a protest. Besides from the critic from the sociology viewpoint, which is people will never have the same negotiative power that the government, let alone the police, and let alone the police in Chile, for example, which is almost a constitutional autonomous body. Which is the legal take on this? Which has been the legal take on the TPM regulations? And I think that here we don't have such good news, because as Kate mentioned, these regulations are accepted as long as they are content neutral. So governments can discriminate among those who are asking a permission or notifying the realization of a protest. And this is something that the general comment number 37 in paragraph 22 has also recognized once again. The second point is that, as Kate also mentioned, is that these regulations are accepted as long as they are content neutral and as long as they are also proportional on the rights of the people. And actually, general comment number 37 has some specific paragraphs on TPM regulations. Which is the problem with this? And I finish with this last slide. So first, I think that these regulations have permitted the states who have been successful in doing this to deprive protests of their disruptive potential. So the idea is that if you protest, you disrupt regular life, and by means of that disruption, by creating uncertainty, you amass social power that then you are going to translate into political power. So you, as a manifestation of public opinion, are going to bring political power into the table so we can actually negotiate some measures to alleviate, I don't know, for example, access to housing for some people who are protesting for that. But by means of these regulations, states have been successful in trying to deprive protests of that disruptive potential. And in that sense, they have placed a tremendous burden in, they have actually permitted transformed protests in some forms of choreographies that take place in public spaces, but that have not been that successful in bringing the states into account. The second thing is that law, international human rights law, constitutional law, is normally content with these facially neutral policies. But the problem is that these facially neutral policies have an equal impact depending on who is the social group that is concerned. So Kate was mentioning that you need a certain amount of money to fund an NGO, and of course that may fall harder on the shoulders of some groups than in others. So again, if protest is for some groups the only means available to take part in public affairs, then these facially neutral regulations are going to be felt harder on the shoulders of those who only have the protest at hand to present their claims. And finally, I think that one of the things that law is pretty like successful in doing is that it's able to proceduralize our discussions. So we are discussing whether protests are legal or illegal, whether the organizers have notified authorities about the manner, the times, and the place of the protest, but we sometimes overlook or don't pay the attention that is needed to the substantive matters that those who are protesting are placing. So these are how we can solve this. I don't know, but I think that one possibility is to bring the principle of equality into the table and abandon this pretension that laws sometimes have of treating everyone exactly in the same way, because what we, I think, need is to open the conversation and the possibilities of treating different peoples in different fashion, and this is something that is quite important precisely when we are dealing with the right to protest. Thanks.
Thank you, Domingo, and thank you, Kate. We have just over 5 minutes, so I'd like to open it up for questions from the audience. Yes, Kaiko.
As for the COVID-19 situation, I think the government provides excessive restrictions, but the strong counter argument by government is just to protect the citizens' life. So I'm just curious about how do we overcome the government's strong argument just to protect the citizens' life?
Were you able to hear that, both of you?
Yeah, I think so. It's an excellent question because, as I mentioned in the beginning of my presentation, it is permitted to place restrictions on these civic freedoms in certain situations, right? And one of those situations is for the protection of public health. So there's nothing per se which is wrong with the government, restricting individuals' expression, assembly, or association in pursuit of a legitimate public health end. The thing is, it has to be done correctly, right? So, for example, any restriction which is placed on a population must be the least intrusive possible in order to achieve that end. And what we're seeing with the COVID-19 restrictions is that the governments are basically using COVID-19 as a pretext to issue these incredibly broad limitations. As just one example, something that we've seen proliferate all around the world with COVID-19 are governments basically declaring a state of emergency, which give the executive certain powers to deal with it. Now, maybe a state of emergency is warranted, but what's not warranted is governments issuing a state of emergency with no sundown clause, which is to say no end to the emergency, right? Under human rights law, if a government is going to issue a state of emergency, they say this state of emergency will last for, let's say, a month, and then at the end of the month, we will look at the situation again and see if we need to prolong the state of emergency. But instead what's happening is you get governments that will issue state of emergencies that don't come with a deadline. And so that state of emergency can last for years and years and years because unsurprisingly, when governments give themselves more power, they're very loath to walk it back. And so we've seen over 100, emergency declarations in the last year and a half, and many of them don't include a time limit. And stuff like that is very problematic.
Thank you.
Domingo, do you want to add anything?
No, I just want to add that of course, rights and freedoms are not absolute. They can be limited. And I think, and I agree with Kate, the thing is that we don't want the governments to drop limitations or regulations, but to explain and justify them. So, for instance, many governments place limitations on the right to protest, even when the levels of spread of the virus was low. So why do we keep the same level of restrictions that were in place when we were, in the phase in phase 1, when we are now in phase 4? And also, some governments have treated different kinds of activities in an unequal fashion. No, you guys have actually, the Supreme Court decided a couple of cases where religious cults were being mistreated actually in face of other activities. Well, the same has happened in protests. Sometimes you have some restrictions placed on protests that have been more relaxed when it comes to other kinds of activities. Kate was mentioning running in groups. Well, you were able, for instance, here in Chile, to run in groups during the pandemic, but not to use public space to protest. And by the way, we are just finishing next Friday a long state of emergency. It was almost a year and a half of the state of emergency through which the government was able to bring the military to control the uses of public spaces and everything that Kate mentioned. That's a severe restriction on civic freedoms.
Any last questions? I think we have time for just one more. Yes, please.
I will speak up, but thank you all for being here and speaking with us. I guess as you were talking about the peaceful contingency that's always placed on protests, I was thinking about property rights and how we don't have the same standard for property rights. Like, if somebody walks on your land and they trespass, for some reason we think it's logical or like it's okay to like shoot that person, but we don't require people to be peaceful in protecting their property. Why do you think that disparity exists in the standard that we apply to those separate rights?
Thank you. Okay, Domingo, should I repeat or did you hear that?
So I hear it, and well, I take it more as a comment because I agree with you. I'm always, well, not always, but I'm repeating the same argument. Why do we have this requirement on freedom of assembly? Why freedom of assembly has to be pacific? And I agree with that, but we don't say the same express requirement for all other rights. And it's very important that you mention the right to property, because if there is one right, and I'm not going into the details of the American Second Amendment, but like regular rights, but if there is one right that you can actually exercise in some violent way, is precisely the right to property. So why don't we have the same requirement of exercise your rights pacifically when it comes to property rights? And I think again that the only explanation is an ideological explanation, which comes from the fact that the government and the liberal constitutionalism gets nervous with the people on the streets. Governments are confronted by protests. Governments are brought into account when the people demonstrate. Governments are pushed to do some things that they otherwise won't do when the people is demonstrating. In the case of Chile, the government was forced to open a constituent process that was not possible to open in the last 30 years, so we can overcome Pinochet's constitution. So this is the reason why the governments and the liberal legal panorama don't want to see the people on the streets. And I think this is the only reason that explains why we place this heavy burden of freedom of assembly. If you take a look to every constitution that includes the requirement of exercising this freedom pacifically, you will see that that word, pacific assemblies, has only been used to restrict the use, the right to protest. Because again, when a demonstration becomes violent, we can point to examples that we all will agree is a manifestation that shouldn't be protected by freedom of assembly. But there are many cases that turn around the borderline, and probably we don't going to have much elements that we can all share, so we can actually agree that this is a violent or this is a pacific demonstrations. But in the end, it has only been used as a means to restrict freedom of assembly and the right to property, or the right to protest.
Kate, any last thoughts?
No, I don't have any last thoughts on that question, although there was just one thing I wanted to add to the question before that, which is something that we've been seeing with the COVID-19 restrictions, is a very discriminatory use of them. So for example, I think in Indonesia, but I might be getting the country wrong, we saw an instance where the government used its COVID-19 restrictions to break up climate change protest around mining operations that were happening, but then they allowed the mining operations, which also involved groups of people gathering together, to continue. So that's another problem with a lot of the COVID-19 restrictions that we're seeing.
Can I add something very quick on what Kate just said? In Latin America, there were many demonstrations and protests that were conducted by people who, being restricted to work and to use public spaces, didn't have anything to eat. So these were called hunger protests. And so we have these two interests in the balance. On the one hand, we have to protect people and public health, so don't go out, don't share spaces, don't use public spaces. But on the other hand, these very same restrictions were prohibiting people to have access to the minimum means they used to have, so they can actually have access to food and to minimum wages. So it was a huge challenge for governments and for courts to put those two interests in the balance. On the one hand, you have to protect public health, but on the other hand, the people were asking the government to do something so they can actually survive the pandemic and not because of the virus itself.
Well, a huge thank you both to Kate Barth and Domingo Lobera Parma for joining us today, and for all of you for joining us. A round of applause. And so that you were able to see our very excited audience, and thank you also for those who asked questions, and we look forward to seeing you for our next event. Thank you.